So, what would you do if I said they can move it out, put it outside the premises, you got to come get it?
That wouldn't be fair. 'Cause
Pardon? That what?
It wouldn't be fair because
It wouldn't be?
my whole life is in there, Your Honor. I have to pack my stuff, my children's stuff. People just coming in and just taking your stuff out.
File number is 241243LT. Casey Strong is here on behalf of the park. And this is a motion to set aside the conditional dismissal and reinstate the case. Very often, in fact, most of the time, once there's an affidavit of default submitted, the case is automatically reinstated. And then it proceeds to a termination of tenancy, or often a writ. Ms. Strong has alleged that there was a conditional order of dismissal entered, and that you violated number 2 of the agreement. The defendants have allowed unauthorized occupants to reside in the unit. I have personally observed unauthorized occupants at the home for extended periods of time. I have personally observed the vehicle of unauthorized occupants in the driveway of the defendant's unit overnight. I sent a text message regarding the unauthorized occupants to the defendant and confirmed that there was an unauthorized occupant at the property. Upon information and belief, the unauthorized occupants are still at the property, and the plaintiff contends that you are in violation of the terms of the conditional order of dismissal, in which case they would ask for a writ of eviction. The conditional order of dismissal was entered October 1st. The defendant shall be permitted to occupy the premises at Lot 31, pay all monies due. The defendant shall not permit any occupants to reside in the residence other than those listed on the lease and approved. Defendant shall not permit the presence of any pets on the property unless approved by the management attached to the lease. Defendants will maintain their property in compliance with the leasing agreement and all local ordinances and regulations. Defendants will comply with all other terms of the lease agreement. Defendants will be subject to the terms of this agreement, and it should be actionable for a period of default from the date of this order. Probation period for 1 year. So the affidavit that I read from Melissa Wing would indicate that unauthorized occupants are in the premises in violation of the conditional order of dismissal. Is that the substance of it, Ms. Strong?
Yes, Your Honor. And if you look at the documents that were submitted by the tenants, they state that they were allowing individuals to stay with them in violation of that agreement.
Ms. Wing, do you have a name of these people?
All I know is when I texted one of them, I wasn't sure who was responding. I assume Bill was responding, because on October 29th, I asked who had been there for the last couple weeks, and he replied it was his cousin staying because they were going through his mother's belongings. I assume there was a death or something. And I reminded them that we had just signed an order not many days before that they would comply with the order. And he responded, well, that it was his cousin staying there. And then on November 8th, I reached out again because the same vehicle was there. So it was a significant amount of time he was there.
No.
All right, Ms. Wing, would you please raise your right hand? You swear or affirm any testimony you're about to give in this manner will be true to the best of your knowledge and belief?
I do.
And do you swear that the information provided in your affidavit of default, which was already sworn to in front of a notary, is true to the best of your knowledge and belief?
Yes, sir.
And you also indicate that William Wadsworth told you that it had been his cousin staying there?
Correct.
All right, Ms. Wadsworth, Mr. Wadsworth, and Ms. Jackson, what's your position?
I emailed Elaine. I know it was last minute. And I emailed.
All right, well, just a minute. I'm going to put both of you under oath also. We both please raise your right hand. Do you both swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
Yeah.
I do.
All right, go ahead.
I emailed Elaine a copy of an answer to this. It was last minute, but with the holiday weekend, it's been very hard to contact anybody or get any help with
Well,
anything.
Ms.
But-
Strong referred to it. I don't believe I have it, so go ahead and tell me about it.
It was, let me just grab it. No, the text message that it was a copy of the text message as well that she sent, which she asked whose vehicle was there. Not been staying there for a couple weeks. That's not the message. And I did screenshot that and send it in because she just asked whose vehicle it was. It says that they cannot reside here, and in the lease it says over 7 days, and that's definitely not the case. He's been here helping give us rides to work because our car broke down, and taking me to my kids' sports and stuff at the moment, just very recently. But he doesn't stay the night here. We can get documentation if needed of who he lives, where he lives, and all that. The week that he wasn't even here, 5 days, and it was just dealing with, his aunt and his mom, passing away, but that's not subject to our violating our lease. So, and I tried to send in the screenshots. I'm not sure how to.
Well, the reason they wanted to terminate your tenancy in the first place is because of unauthorized tenants in the premises. And then we signed this conditional order of dismissal and are right back in the same boat. And so it seems like you were cavalier about it. But I'm looking for the original.
The first one, she said it was comply with the legal related to health and safety, disruption of quiet enjoyment, and then failure to pay on time 3 months.
Your Honor, we brought the action under multiple portions of MCL 600.5775 because there were numerous behaviors that were fitting the violations.
Here it is. Fail to comply with a lease related to health and safety, disruption of quiet enjoyment of other residents, fail to pay rent on time. And some of the allegations were that it was your visitors that were causing the problems. You agreed to this conditional order, and now they contend that you have violated it. Under Section 5 of the lease, guests, without the landlord's written consent, any guest stay shall not exceed a total of 7 days of any 12-month period, commencing with the first day of the guest's appearance. Any person who is a guest and seeks to stay more than 7 days must be screened by the landlord.
And we haven't had any guests residing here for 7 days. Either time. It's like,
All right.
I mean, it's like saying we have different, I feel.
All right. The stuff you were talking about came to the court at 2:05,
Yeah.
and the clerk just handed it to me. There's no dates on this. Hello. Just check in to see who the blue SUV is that's been staying overnight. I thought we were on an agreement and you guys were going to follow it. Before I reach out to the attorney, I'm going to give you an opportunity to reach out to me and explain. It belongs to my cousin and his mom. My aunt just passed away. We're helping him look over her will and complete other legal matters. He says today he'll have my aunt's belongings, moves out of her house, and everything else taken care of. Can the hot water heater be turned back on now?
There was nothing about it being several weeks or date or whatever. I'm sorry, I didn't remember exactly what she said, but that's what the case that we received anyways. So she asked and we did promptly respond. I mean,
been here for a couple weeks.
He was still on
All
there.
right, her affidavit says, I have personally observed unauthorized occupants at the home for extended periods of time. I need to parse that out. I have personally observed the vehicle of unauthorized occupants in the driveway of the defendant's units overnight. I sent a text message regarding the unauthorized occupants to the defendant, confirmed they were unauthorized occupants at the property. Upon information belief, the unauthorized occupants are still present at the property. That was dated November 13th.
Which he's been here. He has to give me a ride. We work opposite directions. So, and right now we're carless, just temporarily. So if his car's here, he's allowed to give us
Well,
a
just a
ride.
minute. I didn't ask you a question. And
Okay.
so you're just volunteering information, trying to get all this. So Ms. Wing, you swore under oath, the conditional order of dismissal was entered October 1st. You filed your affidavit on November 13th. When you said the person was there for an extended period of time, that's from when to when?
Well, I was on vacation, came back on the 26th. He was there the length of my vacation, and I was gone.
All right, the 26th of what?
October. I was gone from the 16th and back on the 26th. He was there that length of time as I was checking the cameras, and complaints from the neighbors as well. And then on the 29th, I had watched them over the weekend and went up at night, did some drive-throughs. The vehicle was there overnight. He was seen coming out in the mornings, going in the evenings, and throughout the day. And then I reached out to them on the 29th and they responded. And then again on November 8th, before I even sent it over to the attorney, I gave him another week to cure the problem, and he was still there. And last night his car was there when I drove through at 10:30 p.m.
Yeah, and he was taking Phil to work because he works third and 3 rivers.
Then continues.
All right, her testimony was that there's video evidence of showing when he comes in and when he goes out. His car's there all night, and he was there. We just did this on October 1st. By October 16th, he was already there for at least 10 days. And if she's correct, all the way through the rest of October, all the way through November 9th. So it's her contention he's been there from at least October 16th to November 8th. And there's video evidence to support it. What's your position?
I
Hope so.
Yeah, there's video evidence of it.
I'm sorry, I couldn't understand either one of you.
I don't know if there's video evidence of it. I hope there is. I haven't.
Who is this person? What's this person's name?
Yeah.
My cousin Jeff. Kurt, sorry.
His
Cousin Jeff?
Kurt.
Say that again.
My cousin Kurt. My cousin Kurt, sir. Sorry.
All right, I'm going to grant the motion. You won't even tell me what the guy's name is. Her testimony is that he's been there for and you won't even tell me his name. No wonder the neighbors are complaining.
Can hear you.
Go ahead.
No, he just gets nervous. I was trying to get him to speak up, but we can provide proof of whatever you need. I mean, if of what the person, of time, of date, of whatever. Uh-huh.
Well, they just did. She testified under oath that he was there from the 16th of October to the 26th, and he was still there after that. And you won't even tell me his name. So,
he's here if he's here during the day, he's given us rides to work. If she's got evidence, please bring it forth. I think she should bear the burden to prove it.
She just did.
By proving with video, but she doesn't have it.
Well, she told me what she saw. Your version is he's there all the time, but he doesn't really live here. The neighbors are complaining, and he won't tell me what his name is. So he's an unauthorized occupant. I don't even know who he is.
I told you I'd give you his
Cousin
ID.
Jeff, cousin Kurt, you don't know his name. And so,
okay. No, 2 wins. We should have one. We can do this. Yeah.
All right.
I don't understand. You don't even have to.
Now you keep muttering. Is there something you want to say? You're both like mumbling under your breath, and I can't understand what you're telling me.
No, I was talking to him. Sorry.
Your Honor, if I might add, not only is the cousin frequenting the home, but in the previous eviction, it was noted that there was a couple of women who were homeless living in the woods right behind the park. We've since put a fence up around the community to try to make that a little safer for our tenants, but those same 2 women are frequenting almost daily. I don't know if they're coming to take showers or eat, but they just walk in the home when nobody's there. They just come and go as they want. I think they're pretty much doing anything but sleep in there.
No.
Do you know their names?
I don't, but they're also on the video.
I hope so.
Yeah, I need some of this video. I need to see this video.
Strong, what are you asking for an eviction date?
Your Honor, I believe this hearing was going to be in person. So knowing that it was going to be by Zoom, we submitted an order of eviction and judgment to the court last week.
I have it. I received it November 26th.
Somehow,
But are you asking for immediate possession?
Be willing to give them 7 days. I mean, it's kind of hard to pack up a house overnight, so I don't want to be that disgusting, but I would be willing to give 7 days.
All right, I reinstate the order for termination of this tenancy, and the writ of eviction will enter 7 days from today, which was November 9th or December 9th.
Mm-hmm.
Mr. Wadsworth and Miss Jackson, you got 7 days to move, or the sheriff can come put your stuff out. The title of it is Riverside Townhouses versus Catherine Yoder. Catherine Yoder is here by Zoom. Laurie Kalmbach, the manager at Riverside, is here. Meg Bauer is here from Legal Aid, and Carrie Zanin is here on behalf of the Cox Law Firm. They're very busy. We did call and clear the state to see if they would have somebody available, and apparently Ms. Zanin drew the short straw. So here she is. So let's back up. The plaintiff sued for black rent in a non-payment of rent case. At the time the matter was filed in September, the arrearage was $1,186. Now, we just had a previous case, 241208 LT, dismissed in August. So by the time of September, she's now alleged to be $1,800 in arrears. So she was personally served with a complaint, and we had a hearing on November 15th. And let me look at the signed copy.
Judge, I've
The
got
defendant, here it is. That was on November 15th. The amount of rent was $718, $184.47, and for a total of $902.47 due by November 25th, or the defendant was subject to eviction. As I indicated, she was personally served. She did not appear. We got an email from the defendant on December 4th. In point of fact, if plaintiff had sought the eviction before that. But anyway, it wasn't a formal pleading, it was an email. So it doesn't have anybody's heading on it. She didn't pay a filing fee. She simply said an email, didn't give service to the plaintiff, and said, I respectfully request that the default judgment entered against me be set aside. I was unable to make rent payments for the month in question because I was not working during that month due to challenges. I live in an income-based apartment and technically should not have been required to pay rent during those months. As I indicated, we just resolved another case for the same tenancy in August. I understand the importance of meeting financial obligations and other important meetings such as the scheduled court dates that I failed to attend. I did not attend to avoid my responsibilities. Fortunately, due to my mental health challenge, I was unable to respond to the lawsuit in a timely manner. I asked for the opportunity to present my case fully and discuss a fair resolution, including the possibility of payment arrangements. I am committed to resolving this matter and sincerely request the court's consideration to set aside the default judgment. So we treated it, even though it was just an email, without notice to the other party, and I set this emergency hearing. As a general rule, when a party moves to set aside a default, they have to show, they're supposed to file a meritorious, an affidavit of a meritorious defense and show good cause for why they didn't show up. The defendant had shown up for hearings in August. She was personally served. She didn't show up for this one. She makes some veiled reference to the fact that she had mental health issues. I'm not sure that rises to a legitimate reason for failing to appear, and a meritorious defense. Her defense, I guess, is that somehow her rent should not have been set in this amount. As I indicated, we just dismissed the other case in mid-August. She had apparently paid some rent because the claim was for more than what the judgment actually entered. So we asked the Cox Law Firm to be here. We forwarded a copy of the defendant's email to them, and Attorney Carrie Zanin is here. Ms. Zanin, what's the plaintiff's position?
Well, Judge, was going to argue the court rule. I don't believe that good cause was, well, first, I don't think we even need to get to the good cause and the meritorious defense, as this motion should have been filed within 10 days. And motion, email, the judgment was signed on the 15th, 10 days would have been the 25th. She's an additional 9 days beyond that date. I don't believe she's, in compliance with the court rules as to the time frame, and I don't believe she's delineated good cause to set aside. She was personally served. She had the court date. She didn't appear, and I don't believe there's a meritorious defense either. As to your questions about the August, I can tell you by looking at the ledger, she did make a payment late in August that brought her balance down to $70, and that's probably why the dismissal. And then, of course, September, October, November, and December are now due. So I would ask that you deny the motion.
So is it your position that once she made the August payment, that no payment was made for September, October, November, or December?
No, Judge, her balance actually right now is $923. So there's been small payments made since the date of the judgment. The only payment that shows is the utility reimbursement, so I apologize. So, but what I'm showing at this point with December is that she owes $923. So an extra $20, Judge, on the judgment.
All right. Now, sometimes there are a couple things. When you fail to appear in a landlord-tenant case, you have 10 days to appeal. And you didn't file anything within 10 days. You filed it on December 4th, which is 19 days after the judgment entered. Now, theoretically, on a motion to set aside default, you have 21 days to move to set the default aside, but that's in a money judgment. This was a landlord-tenant judgment for possession. So there are multiple issues. One, there's no meritorious, well, it's multiple. You didn't properly file it. It was filed more than 10 days after the appeal period. It wasn't served on the other party. We served it. You didn't file an affidavit of meritorious defense, and I'm not sure there is a meritorious defense. You simply owe the rent. Somehow it's your contention that it shouldn't have been calculated as this, but we just had another case about 3 weeks before it, and you're employed now and working somewhere in what looks like a good job. So they want to stand by the original order. That's now 9/23. So what are you seeking at this point, Ms. Zanna? An opportunity for her to pay the rent or a writ of eviction?
I believe we are asking for a writ of eviction based on the judgment that was signed on November 15th, 2024.
All right. Ms. Yoder, what's your position?
I'm wondering, what job do you feel that I have? I've been unemployed
Well, you said
since
you were
July.
out of state as at a conference.
That is not related to work, Your Honor.
Oh, okay. I thought it was.
And I've been unemployed since July 25th. And the reason why I've not, she's giving me the $528 rent fee for August is because I neglected to let her know that I quit my job at Gemstone Solid Surfacing in Elkhart, Indiana, July 25th. So she's putting that $528 for rent in August, and then the extra fees are the court fees for the missed court hearings that I missed. So how am I supposed to pay for that with no job? Plus, I've had interviews. I've applied for over 30 jobs remotely and out of in the workforce, and I've not been able to get hired. For that reason, I really don't know, other than the fact that I've been trying to do my best.
Well, I respect that, but none of that's a defense of the fact that you haven't paid your rent. Now, Ms. Kalmbach, could you unmute? She says she quit her job. Did she ever notify management or ask for a recertification?
She did, and that's why she owes the August rent, because she did come in and we did take her down to zero.
All right, so she owes August rent, but not, she's zero currently.
Yes, September 1st, she went down to zero rent.
All right, so how do we get 9/23?
Let me look at her ledger. She had some non-sufficient funds because she wrote us a check on a closed bank account.
Well, she had told us she didn't raise any of this. She said she was going to pay it. And then some checks bounced. And let me back up. We were here on November 4th. She wasn't here. On November 4th, another attorney from Cox Law Firm, Jen Wilburn, was here, and Ms. Kalmbach was here. Defendant had brought in a check. She was nervous about it. She wasn't sure it would clear. The arrearage was $658, and that was through November, and it was $184.47. So it didn't include, she brought in a 658 check, but did not include legal fees. So she missed the first hearing on November 4th. But because the check had come, I waited to see if it cleared. I continued it to November 15th. Ms. Kalmbach indicated that the check had bounced and did not clear. The defendant did not appear, and I issued the default judgment. 718, 184.47, and 902.47 total. The check came back as account closed, which actually is a misdemeanor. And so the check didn't clear, the account was closed, the defendant didn't appear. She didn't file anything within 10 days, and the plaintiff still wants her to move out. All right. So,
Your Honor, could I add something else?
yes,
Back in July or August, I believe, the landlord came in to check my ceilings, and she had said that she was going to come get them fixed. And when you look at my ceilings, I can provide photo evidence as well if you need that. It's bowing down. And there's been 2 other tenants that I know of personally whose ceilings have caved in and fell.
stop. The time to raise that defense was at the time of the hearing. We were all here. Now you haven't paid the rent. You didn't file it at a timely manner. You didn't file it properly. You didn't file an affidavit of meritorious defense. And now you're raising some habitability issue that you had 2 opportunities on November 4th and November 15th to raise. So I adjourned it because you had presented a check. Not only did it bounce, the account it was written on was closed. So payment wasn't received, then you didn't appear on the 15th. Ms. Kalmbach or Ms. Cox, do you have any interest in allowing her an opportunity to pay the unpaid rent or simply ask for a writ of eviction?
I think at this time, Judge, we're asking for the writ of eviction.
I don't believe I've received it yet. Let me look.
I would rather pay the 528, meet you in the middle with that. I'm going to have to get some help, but I would be glad to do that because I don't have anywhere to move to right now.
Yeah, I do have the writ of, they don't want you to do that. I did get the writ of restitution eviction on December 9th. The motion to set aside the default is denied. It's outside of the 10-day appeal period. Even if it was considered that it was filed within 28 days, there's no good cause shown for failure to appear, and there's no affidavit of meritorious defense. They don't want you as a tenant anymore, and it's going to show as an eviction on your record, which may make it very hard for you to get into any other subsidized complex. They don't, theoretically, this order will allow them to evict you tomorrow or Monday morning, but maybe they can work out some sort of accommodation or agreement. But I will sign the writ of eviction. So you're in a difficult spot. It's right before Christmas. You had 2 opportunities to be here. You did not appear. You presented a check for payment, which was on a closed account, so the payment wasn't made. And to further put salt in the wound, your current rent is 0. You're not going to be able to find rent for 0. So my suggestion is that you go in and meet with the manager and see what you can work out for a move out date. They don't have to serve this order for 56 days. But they can serve it immediately. That's been held since December 9th, and today is December 13th.
Can I at least get my things packed up and in a U-Haul so they're not
Yes, I'm sure
putting my
they'll agree.
things out in the street?
It's a lot easier to have you do it than have the sheriff do it, so I'm sure they'll work with you regarding that. All right, like I said, I don't have to like it, I have to follow the law. All right, that completes this record.
We represented ourselves.
All right. Where are we in regard to this case?
So, Your Honor, I filed a motion to dismiss. I'm not sure if that came into your chambers yet.
What's the basis of your motion to dismiss?
The fact that the water bill is what I'm being charged for as non-payment of rent. The water bill is high due to a broken wax ring in the toilet. As per a contractor that Ms. Jelani hired, who stated that this is the cause of the entire problem, and that's never been fixed. That was the first time when the ceiling collapsed. They figured this would happen. So a year later, this was not professionally done. She dismissed this contractor because she didn't want to get it done right. She hired a family friend who did not fix it right. She did not replace the tub or the toilet or fix the wax ring. So because of that, as per his expertise, he stated that.
How much is owing?
I'm sorry?
Your Honor, if I may, these two cases were consolidated. There was originally a non-payment case, and then there is a termination of tenancy case as well. Quite frankly, we're just looking for possession back, and I'd be more than happy to dismiss the non-payment of rent.
There's no lease.
The lease expired in May.
So there's no lease.
We're at a month to month, and I want to leave. I can't leave because work is being done.
Says what?
The work is being done in the home, and there's mold in the home. I put that all in the case that
I understand that, ma'am, but what they want is for you to vacate the premises. And so you're telling me you can't leave because why?
Because there's mold in the home and it's not safe to go in. There's no movers who will go in there. I don't want to stay there, but I can't get my stuff out because when we left, everything was just as it was. And it's been that way since August till today. So till today, work is not being done. If you go in there, from what a mover I did send over there saw, the floors are missing. They're not going there. It's not safe.
Your Honor, a little context maybe to help the court. If the court recalls, back in August, there was a loss at the premises. The defendants vacated. The only thing remaining really is their personal possessions. And that's really all we're trying to get is their personal possessions.
And I can definitely do that as long as it's safe to go in for someone. I'm not gonna get sued for.
Well, who said it's unsafe?
A couple of things. There's a sticker on the doors.
What sticker?
There's a sticker.
If I may, Your Honor.
There's a sticker on the door by the fire chief. Do not enter the property unless you're working on it.
Correct.
Right.
Which means that you can enter the premises.
Right. They can enter the premises to do work or to move, but companies are not willing to go in like that. I had one company call before.
This makes no sense to me.
They won't go in.
Disagree, Your Honor. If again, some context, when the loss occurred, they shut off the water because it was a water damage issue. The water and that.
I don't even need to know that.
Okay.
When are you going to get your stuff out?
As soon as they're done working on the property. Or
no, it doesn't work that way.
Okay.
You've got to get your property out.
Absolutely, but no one will go in there and take it out because of the status of the home.
Who?
Your Honor, my clients don't even have keys. The only keys.
There's a lockbox on the door, and she has access to the property.
She doesn't. My client doesn't have any access. We're just trying to get the property back.
And I will gladly give.
Why are you guys talking over each other?
I'm sorry.
I have repeatedly requested just a date or a time frame to get stuff out, and I'm still not done.
When there's floors, then people can go in and take stuff out. There's no floors to walk on, and there's no.
How much property's in there?
A lot. My whole house, my whole life, Your Honor.
So, what would you do if I said they can move it out, put it outside the premises? You got to come get it.
That wouldn't be fair.
Pardon? That what?
It wouldn't be fair because
it wouldn't be.
My whole life is in there, Your Honor. I have to pack my stuff, my children's stuff. People just coming in and just taking your stuff out.
But you can't just sit there and not do anything.
I'm not, sir. I'm looking for someone who is willing to go in there and remove my items.
Then what you need to do is I'll pass it, take a break. You need to call. I want to know who you called. Find somebody before you leave here today.
Thank you, Your Honor.
So I have to have my stuff out by today.
What did I just say to you?
He said, find somebody.
You need to call somebody. You can use your phone, look up whoever you got to look up,
Okay.
call them, find somebody that's going to move your stuff and when they can do it.
Okay.
Thank you.
All right, thank you.
And then I'll call the case back up, but don't leave the building until such time as I tell you can leave, because we're going to get a date today. And that was fun. Okay. Go ahead.
So I called several companies and they posed a very valid question that I forgot to bring up. Where will you be taking your items to now? I don't have any place to take it because I'm displaced because of the landlord's negligence to fix the housing, the ceiling collapse. So I'm in a hotel with 4 children. I have nowhere to take it. That's one thing. I need time to find a place. I've been looking since May. And even more now in August, and nobody wants to rent with me because they're like, you know, you have an eviction. So I did ask though, I said, well, if I had to move the stuff, could you come? There's mold present. 2 men in a truck said, no, they're not doing it. I can call, put Debbie on the speaker. This side up moving said, absolutely not. That's via text because of the mold present. A third party, he says, he has to see how bad it is, but with mold, he can't send his guides in there.
If I may, Your Honor, my client would be happy to give 30 days to get their stuff out, and after that, the writ would issue. There's other options we can put on the table here to get this over and done with.
I need to be able to find a place to stay. I can try. I don't know.
Okay, so here's the problem. You got to find a place.
Yeah, I've been trying it. Right?
No, you got to find a place.
I,
Because if you can't find a place, so understand what will happen.
okay.
What will happen is I will set this for trial. If you lose that trial, it's not going to, all of these questions aren't going to matter, because what will happen is I'll give them the authority just to put it out on the curb.
Your Honor, I need more time than 30 days to get out of there. It's not like I don't want to be there. I need to find, I don't want to go to trial. I really don't. I want to be done with this, but I need to find a place that rents. If there's something given to me.
Have you asked them how much time they'll get? They are saying 30 days. Have you proposed anything to them about time frame?
Yeah, I've told this to Mr. Evanchik. I've told him that what's going on. I've been in conversation with him. He's just telling me, get out, get out, get out.
Okay, fine. But if he's saying 30 days, have you given him a time frame that you could do it?
He never said 30 days, but I cannot.
Okay, he just said 30 days. Do you have a time frame that you could do it?
I might need 90 days because there's an eviction. If the eviction can go away and I can get something from the court showing prospective landlords that I'm not on eviction, I'm not being evicted, I was never evicted, they will rent to me. My credit is fine. It's not the issue. It's just this fact. I didn't want to spend Thanksgiving in a hotel with my 4 kids or Christmas or their birthdays.
30 days, conditional order dismissal.
30 days is not enough.
With the reinstatement in the event that
Your Honor, excuse me, Your Honor, can I speak, please, if you don't mind?
Sure.
Okay, Miss Janet Garden has been staying with us. The biggest problem out of this whole issue is the kids that are involved. And they came out of that house. My nephew was in the ceiling fell, almost killed him. She just lost that. She lost one of our child during COVID. So it's been like an emotional roller coaster, a single mom with 4 kids. She's been paying our rent to this, the landlord. I've been helping out this family. And it's just to see when things happen and there's a crisis. Within those crisis time, everything everyone wants in the society is money, 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 money. Not forgetting the people that has been displaced in this situation.
Ma'am,
They didn't
that's not
really
true
know.
here
Unless
because they
they-
said, ma'am, that's not true here because they said that
The
they
guy's
just
been
want
so
the premises.
aggressive. The guy's been
Wait,
very
let-
aggressive.
Okay.
What do you guys want to do?
I need more time. I will leave the
Then
premises.
what I'm gonna do is I'm gonna send you out there, talk to Mr. Evercheck. You guys try to figure out a time.
He's very aggressive,
Your
sir.
Honor,
He's very
Wait,
aggressive.
hold on.
All right, then you're gonna need to talk to me.
Yes.
If
Your
you
Honor.
want the bottom line of aggressiveness, you're gonna have to talk to me.
Yes.
So I'm gonna pass the matter. Have a seat.
Yes, sir.
Okay, folks. So we are not any further along than when I last left you, I'm presuming.
No, Your Honor, I did try to discuss this with, not successful.
And ma'am, what is your, there's no lease.
No.
So I guess the question becomes, why wouldn't I just give them a judgment and give you 10 days to move?
Well, because there was conversation of continuation of a lease prior to this collapse. And if it wasn't for the collapse, I probably would have at this point found a place to stay. And I would not be in a hotel spending thousands of dollars. And we wouldn't be here at all. And there would be no eviction. And I would have been able to get a new place smoothly and have my family safe and happy.
But you understand that I really don't, other than maybe a few equities that fall to your side, have a reason to delay it. I mean, here's the reality of it. The reality is you're going to need to move.
Yes.
All right. So from my standpoint, it's the issue of time. And you're saying you need 90 days.
At least, sir.
Well, that's not going to happen. I mean, I can tell you, I'm not going to issue a judgment for 90 days. Is rent being paid?
No, because the property is not habitable.
Got it.
There is rent and escrow from when this originally started as a non-payment, $2,500. So we would ask that be my client.
No. If it wasn't for the landlord's negligence, we wouldn't be here to begin with.
Okay, well, I can solve the escrow issue right now. I'm not returning it to anybody right at this moment. Okay. Because the issue is a move out.
All right, so how much time can you allot me, Your Honor? Because, I mean, there'll be another case with the situation of the housing and all, but right now they want possession. So what's the maximum amount of time you can give me, knowing that no one is willing to come and move my property? And also knowing that I cannot find a new place within the state of Michigan with the open eviction under my name?
Well, let me answer it this way. I try to resolve these in a fashion where it is beneficial for both parties. All right. And let me ask you this. Would you be able to get this all arranged in 30 days?
No, sir.
All right.
I can, if you will allow me maybe 60 days, that would be more. If I can also get something from the court or the landlord stating that I'm not evicted. So when I do present my application to new housing, I can present that as well.
And Your Honor, if I may, as we previously indicated, we're happy to do a conditional order dismissal to move this along.
Your Honor, how long does an eviction stay within your court, please? Because they do check that.
What do you mean? How long does it stay?
Like if a prospective landlord's realtor is looking at my name or pulling up records to see.
What if they pull it up and they look at it? And what counsel's indicating is if we do this by way of a conditional order of dismissal, then it will look as though the case is dismissed.
Okay.
And then otherwise, it's gonna look like there's a judgment or a pending action.
Right. Okay.
If they come in, I will say this, if they come in and look closely at the file, they may see something different,
Oh,
but it will reflect as a conditional order of dismissal. It'll look as though it's dismissed. If you comply with all of the terms and plaintiff doesn't have to then issue the judgment and have you evicted, it will look as though it is dismissed.
okay. I don't know how that's gonna help me or hurt me, but what I would like to ask is, did you get a moment to look at my motion to dismiss? Can we just dismiss it all altogether, being that?
Your motion to dismiss is denied. There isn't a basis for me to dismiss the case. In
Okay,
particular, not the termination action.
I'm sorry.
In particular, not the termination action.
Okay, so the eviction is based on $200 that I did not pay for her to fix the plumbing because the plumbing was never fixed. Until the time that
Ma'am, if you want to litigate this case, then you can litigate it. And you're gonna be right at that 10-day period. But if you want to go ahead, you can go ahead.
Well, no, I don't want to be at a 10-day period. I would like to have time to get a company who's willing to move my stuff out with the mold situation.
All right, here's what I would suggest to the parties.
Okay.
That there be a conditional order of dismissal with that the defendant would vacate the premises by January 31st of 2025.
Apologize, Your Honor, I'm not doing the math, but is that more than 56 days?
It is not.
Okay, so we're under 56.
Yes,
I think that works out to pretty close to 45 days.
correct. It's about,
My client's fine with that.
what about you?
Okay, t-shirt. Can I get something next week? I'm sorry, Your Honor, you said.
The January 31st day. Okay. Now, I think in the conditional order dismissal would have to acknowledge that you're not residing in the premises, but that they're and won't reside in the premises.
Sorry, I can't hear you.
That the conditional order dismissal would have to indicate that you're not residing in the premises, will not reside in the premises, but that you have personal property in the or on the property,
Okay,
and that the personal property would have to be removed by defendant prior to that date.
okay,
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 just so that we make that clear. All right. Also, in the conditional order dismissal, the amount held in escrow, that the court will rule on that issue after the defendant has vacated the premises,
okay.
as to where that property would go or where that money would go. And I can give a court date for you guys to come back. I need a court date in February. And that there's a hearing set on the escrow for February 4th, 2025 at 9 a.m.
Do we have to be here in person, Your Honor?
You'd have to submit a form to appear in Zoom.
I'm sorry, sir.
You'd have to submit a form if you're going to appear by Zoom. I'm not guaranteeing that I would say that you can.
Okay,
If you have if everything is out of the property, I'm going to be much more inclined to let that happen.
sounds good to me. Thank you. One more thing. In regards to the mold and everybody denying me to come in because of the mold, is it possible for you to put into the conditional that they can at least show something that the mold has been taken care of? So, because people are gonna have to come in and pack my stuff, so they're comfortable doing.
Well, I'm not going to get into that. I will just say this,
Okay,
that mold can appear there's mold everywhere. The question is whether or not the mold is of a type and nature that exposure to that would jeopardize some impairment of human health.
it is.
I don't know that now.
No, I sent you the mold report.
I understand that, but there are differences there are still differences in that. So, I am not going to, I'm not here to make a ruling and will not make a ruling as it regards the mold and the like. If the folks that move in go in to move your property, have to mask up or do whatever it needs to protect themselves, and they certainly can do that.
Okay.
Because if you don't move the property, the reality is that's precisely what plaintiff is going to have to do in regard to getting the property out of the premises. So, all right. Anything else?
No, if I could just read back through this really quick, Your Honor.
Yes.
And I'm going to be preparing this.
Yes.
So, defendant to vacate on or before January 31st by removing personal property possession. Defendants have already vacated the premises. That the court will hear on 4th, 2025 at 9 o'clock in regards to $2,500 that escrowed. I assume that if we are able to reach resolution ahead of that, then we don't need to come back.
Correct.
Okay, so I will draft this up and submit it to the court, or a copy of both, or post as the time.
All right, very good.
Thank you, Your Honor.
Do either of you have any other questions?
No, that'll be all.
All right, thank
Have a
you.
happy holiday.
Have a wonderful holiday, sir.
You do the same.
Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker remote
Ma'am,
from me.
then I don't know how I'm going to get you into court.
October 4th of this year, I gave the defendant the proper 30-day notice demanding possession of my property because of non-payment of rent.
Well, okay, let me stop you there.
Okay,
A 30-day can't be the subject of a non-payment of rent action.
okay. So.
All right. Do you want her to move or are you just terminating her tenancy? I mean, are you terminating her tenancy and want her to move or do you want her to pay you?
I want her to move and I want to also have a money judgment. So I can't do that?
Yes, you can do that.
Okay, that's what I want.
Okay. Go ahead.
Yeah, and I'm seeking a money judgment from the court for all back that she owes me as of December 1st, 2023, which is $11,995 plus court costs, $215, and service fee of $68.
So how much is your
So the total
claim?
money judgment requested from the court is $12,278.
All right, Ms. Gerler, what do you have to say to that?
Your Honor, when I first moved in, it was to be a temporary arrangement. I had another place lined up that did not end up being represented appropriately. It was to be vacated and renovated. Didn't happen. I have attempted along the way to give Ms. Peel, the plaintiff, money. I became extremely ill with COVID, which I have long COVID, along with 2 other disabilities. When I became behind in rent because of illness and sought help from local agencies, the plaintiff was offered money from Faith in Action, and she declined those monies. And there were other monies from other agencies that would have been available that would have satisfied my arrearages at that time of $2,985. Declining those monies led me to believe that she simply wanted me to move out. So I tried to start packing possessions, became ill with COVID again. I have in the court documents outlined to you the many times since then that I have been afflicted with every COVID variant. I already have a serious extreme condition of electrohypersensitivity that I cannot easily find a place to live. I cannot live in group settings, be exposed to Wi-Fi, wireless meters, be near cell towers. I need a rural environment. I no longer have a vehicle. I cannot use cell phones, smartphones, computers due to my electrohypersensitivity, and I thank the court for granting this Zoom appointment at the last minute since I was not supplied the forms necessary in the personal and mailing service I received, and was actually waiting because in our December 1st hearing with Judge Barr, he informed the plaintiff that she had filed incorrect paperwork and needed to refile. So I have been waiting for that paperwork to come, which I don't know if something changed and was not necessary. But
What
am
incorrect
now,
paperwork? I don't have a notice to that.
well, and that's whatever happened, Your Honor. That's what I heard in court, and I'm not privy to what happened thereafter. I am chronically ill, Your Honor. When I get well,
ma'am, hold
I
on.
cannot work.
Yes, ma'am.
I spoke with my attorney counsel yesterday, and she said my paperwork was fine. I think it was just not clear to Judge Barr what I wanted because I didn't know how to present my case. So,
Well,
but
yeah, I actually see what Judge Barr is saying right now. Well, you filed 2 different notices. That's why. I got it. It's fine. I think. Hold on. That's not that one. Right. You filed 2 different ones, but you got, it appears to me, the correct paperwork. Right.
Your Honor,
So-
just to respond, that's what I heard from the judge. And my legal
Yeah, but
counsel,
this is another judge saying that that's wrong. It's correct.
and that's fine. I have no problem, but I was
Okay,
waiting
good.
on that paperwork. I know that the plaintiff is someone who tries to do things appropriately, but what did not happen appropriately with this home that has been a long time rental is that there is no certificate of compliance on file with the township. And the
Okay, so
application-
when are you going to move then?
Your Honor, I have had to deal with all the demands of the court, so I cannot explore that yet because I was required to apply for SER with the DHS, which was declined. I have contacted every agency available to me thus far.
Ma'am, do you understand she doesn't want you to pay rent and stay? She wants you to leave.
I understand that, sir, but to comply with the court and the paperwork required for this hearing, DHS, that's where I have put my first attentions. I have been packing and moving things out of the house, which they have witnessed, but because of my extreme sensitivities, it is not easy for me to find a place where I can live safely. I have just recovered from my last bout with COVID, which has severely impacted me for the last 4 years and created these issues. And I have also...
Ma'am, I understand all of that. The question becomes, when can you move?
That is a question mark to you and me both, Your Honor. I do not know. I have nowhere to go. I am solo in this world. I have no vehicle. My car broke down June of 2022. And my situation is not a good one because of chronic illness. My energy is not
Okay,
reliable, and sometimes 12 hours in the bed.
okay, ma'am, I can appreciate all of that. But you also have to understand that the landlord is entitled to her premises back.
I understand that they request their premises back, and I have an appointment with Hawk on Monday. To what degree that will help, I do not know at this point. I have been unable to find assistance from anybody because they say I am not sustainable, because I am now forced to live only on my Social Security income, the
Okay,
house line.
Okay, ma'am. Here's what I'm gonna do, because this has gotta. I understand the difficulties that you're telling. I also understand that the landlord needs to resolve that. So I'm gonna set this for a trial. You raised some issues in your answer, but I'm gonna set it for now. Yes, ma'am.
When I talked to my attorney, she said that there is no requirement for the compliance regulations in Webster Township where I live. And she's an attorney from Dexter. So
Oh, they know
And that
more,
was
they know more than us
full-
here, us other country folk from Pittsfield, or what?
I guess. I don't know. That's what she said. Is that correct?
What?
That's what she said.
I don't know. I guess she's from Dexter, so she knows more than us.
Township does
We're
not
just
issue.
little country judges up here. Ma'am.
I actually called the zoning person too. She
Okay,
said-
and she said, yeah, probably
said-
she agreed.
I'm having difficulty hearing, Your Honor. Could that be repeated?
No. Okay, she went to Webster Township. The issue regarding the certificate of occupancy, it really isn't an issue because they don't require it for rental properties in Webster Township. That's the long and short of it.
I would like to know then why Legal Services of South Central Michigan gave me this form and checked
Okay,
it out.
ma'am,
They must
I
have
don't
obviously
know.
researched
You guys keep talking about lawyers. I've not met them. I don't know. All I know is this. You two are in front of me arguing a case. You have one position, plaintiff has another position. So here's what I'm gonna do. I'm gonna set this matter for non-jury trial. It will be in person.
Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker remote
Ma'am,
from me.
then I don't know how I'm going to get you into court.
How is it not possible for me to continue in this manner, sir? I have been before you to establish the severity of my condition. I become debilitated, incapacitated, ill. I lived in the basement of my prior home for 7 months because of radiation poisoning, and by necessity, where your court is located, there are many electronic communication requirements for police, fire, the cell tower, Wi-Fi for the buildings. I will literally fry and be unable to move. That's why I couldn't come today. This is not a fun scenario. And the landlords are well aware of my conditions. They had mitigated the house. They used Ethernet.
All right, ma'am. All right, look. Do you have any problem if I hold a trial and she appears by Zoom?
I guess not. I've been without income for a long time, and my preference is
Okay, look, folks.
Yeah.
There are a lot of folks out there that
Everybody
are
has
having a hard
sad
time,
story.
and I get it.
Yeah.
Okay, I have to deal with it every Friday. So I don't know that I can help you with any of that right now.
Right.
I'm just trying to set a trial date. Do you
Sooner
have
the
any
better.
objection to her?
Tomorrow,
What?
tomorrow, sooner the better.
I'm not coming in
Over.
on Saturday.
How
I'm this is not happening.
about Monday?
No. What? We can do when? What time? 1 o'clock on Wednesday? Oh, no, I can't do 1 o'clock. What time seriously can I do? Non-jury trial, December 20th, 2023,
At
9 a.m.
9 a.m. Okay. And
You need to appear in person, ma'am. You can appear via Zoom.
right here?
Absolutely, that's where I'll be.
Okay.
And if I don't get this docket done, I'll be still sitting here from this one.
All right. Thank you.
Thank you.
Okay, thank you, Your Honor, for the accommodation for my disabilities. I appreciate your sensitivity to the matter and your humor.
Thank you, ma'am.
Bless you. I will sign off now.
All right. Lakestone Apartments versus Leslie Lewis, recall. Where's Miss Lewis? She's not here.